Hello and welcome to this video lecture, which is part of Unit 3 of our program on media laws. I'm Aju John, and in this video lecture, I will discuss how the law of defamation accommodates speech that is very important to the functioning of a democracy. In the reading material to this unit, we learnt about the ingredients required to establish a tort or the offense of defamation. In the previous units of this program, we learnt about how important the freedom of speech and expression were to the functioning of a democracy. Every single restriction on the freedom of speech and expression, therefore, have to be justified on very specific grounds. As we shall see in this video lecture, speech that is very important to democratic functioning, for example, speech that is critical of public officials, needs to meet a very high standard to be considered defamatory. Now, before we learn more, let us also keep in mind the kind of restrictions permitted on the freedom of speech and expression under the constitutions of India and the United States. The first and most important case on this issue in the United States arose from a full-page advertisement in the New York Times in March 1960 titled "Heed Their Rising Voices." The purpose of the advertisement was to raise funds to defend Dr. Martin Luther King against a perjury indictment in Alabama. The advertisement claimed that the Alabama State Police had arrested Dr. King 7 times. In fact, they had arrested him 4 times. Many of the other claims made regarding police repression of the riots were also factually wrong. L.B. Sullivan was the Montgomery Public Safety Commissioner. Even though he was not directly named in the report, in the advertisement, he still felt that its contents were defamatory because he was in charge of the police. He sued for libel. The case came up before the Supreme Court of the United States in the context of several other libel claims which arose against newspapers which had been reporting on civil rights in America. In fact, the New York Times has always maintained that the case against it was part of an effort to intimidate news organizations who were reporting on civil rights in America, and in particular about the illegal actions of public officials from the South who had supported racial segregation. With New York Times versus Sullivan, the Supreme Court of the United States created a new class of defamation for speech that is critical of public officials. The judgment created a shield so that such speech is protected even if it is false, unless there was malice involved. This created what is known as the actual malice standard. What is actual malice? To be considered defamatory, the statement criticizing a public official should have been made with the knowledge that it was false or with reckless disregard of whether it was false. Let us now look at a few other judgments which have followed and expanded on the actual malice standard laid down by the Supreme Court of the United States in Sullivan. Edwin Anderson Walker was a former army officer and a conservative political figure in the United States. Walker filed several libel lawsuits in response to negative publicity about his political views. One of these suits was about the coverage of his participation in a riot at the University of Mississippi, specifically over statements that he had led a charge of students against the US federal marshals, and that he had assumed charge of the crowd. After a Texas trial court found that the statements were false and defamatory, the Associated Press appealed to the Supreme Court of the United States. Wally Butts was an athletic director of the University of Georgia. He successfully sued the Saturday Evening Post over an allegation that he had conspired to fix a football game. In the case of Walker, the Supreme Court of the United States found in favor of the Associated Press. This is because the news had to be disseminated immediately. Moreover, the source of the information had been present at the location of the riot. Moreover, that source had proved itself trustworthy previously. In the case of Butts, the Supreme Court found that the Saturday Evening Post had acted in reckless disregard of the truth because it actually had more time to verify the information. In both cases, the Supreme Court of the United States extended the actual malice standard to apply to both public officials and public figures. In 1971, George Rosenblum, a distributor of pornography in Philadelphia, had been charged and arrested with an obscenity violation. a local radio station called him a smut peddler. After he was acquitted, he sued the radio station and won damages. The Supreme Court, however, expanded the application of the actual malice standard to matters of public or general interest, even if they did not involve a public figure or a public official. When we look at cases that have limited the application of the actual malice standard, the principle that stands out is that the standard for defamation needs to be reduced for people who have not thrust themselves into public controversy. Elmer Gertz, a well-known civil rights activist and professor of law, who represented the family of a 17-year-old boy shot by a Chicago police officer, was accused of being a communist and being involved in a plot to discredit local police forces. He won much higher damages after the Supreme Court overturned the result of a trial court, saying that the actual malice standard had to be lowered in his case because Gertz had not thrust himself into a public controversy. He had merely accepted a private client. Similarly, Mary Alice Firestone was not a public figure. She was only in the spotlight because of a divorce action and had done nothing to thrust herself into the public controversy. Allegations about her regarding cruelty and adultery did not have the protection of the First Amendment. Now, before we look at the situation in the United Kingdom regarding defamation and statements about public figures or statements that are in the public interest, we need to remember a couple of crucial differences between the legal system in the United Kingdom and the legal system in America. Most importantly, the United Kingdom does not have a written constitution, and hence no written guarantees of the freedom of speech and expression that reign over their parliament. That said, the 1999 judgment of the House of Lords in Albert Reynolds versus The Times gave the journalistic process a degree of importance that would help the freedom of speech and expression trump the competing rights of the European Convention on Human Rights. The judgment set out a qualified privilege for the publication of defamatory statements in the public interest. This privilege is available to journalists who had a duty to publish an allegation, even if it turns out to be wrong. However, it would only be available if the journalism was responsible. Unlike the Supreme Court of the United States, the House of Lords was not content to guide the media with principles such as actual malice. It laid down a detailed set of standards of what would constitute responsible journalism. These include the seriousness of the allegation. The more serious the charge, the more the public is misinformed and the individual harmed if the allegation is not true. The nature of the information and the extent to which the subject matter is a matter of public concern is another factor. The source of the information is another one. Some sources have no direct knowledge of the events, and some informants have their own agenda. The court can take these factors into account. What steps have been taken to verify the information? Has it already been the subject of an investigation which commands respect? The urgency of the matter, because news is often a perishable commodity, is another factor. And then the court can look at the tone of the article. A newspaper can, for example, raise queries or call for an investigation. It need not adopt all allegations as statements of fact. Has a comment been sought from the plaintiff? And does the article contain the gist of the plaintiff's side of the story? The application of the Reynolds defense can be seen in the case of George Galloway. A member of the Labour Party and a member of Parliament at the time of the invasion of Iraq in 2003, George Galloway was a controversial opponent of the invasion. Just a month after the invasion, the Daily Telegraph published articles based on documents found in badly damaged government offices in Baghdad titled "Galloway in Saddam's Pay Say Secret Iraqi Documents." Stating that these documents were forgeries, Galloway sued the newspaper. Meanwhile, he was expelled from the Labour Party. During the trial, Lord Justice Eadie said that the newspaper did not qualify for the Reynolds defense because it did not offer Mr. Galloway a chance to consider the documents and because the accompanying editorial did not display a balanced and fair attitude towards the MP. The Court of Appeal upheld the judgment and said that the newspaper was not only reporting what the Baghdad document said, but had adopted and embellished them. The rule in Reynolds was updated in Jamil versus Wall Street Journal. In this 2006 judgment, the House of Lords held that the Reynolds defense was no longer a form of qualified privilege, but a public interest defense. it can be argued that this has brought the English position closer to the American position. And with that, we come to the end of this video lecture where we have learnt about how the law of defamation in the United States and in the United Kingdom is modified when it comes to speech of public importance. Thank you for watching, and before you move to the next unit, please attempt the practice exercises.